Welcome to this session of the Justice Committee. Welcome to our witness, Mr. Ephgrave, Director of the Serious Fraud Office. Very good to see you, Mr. Ephgrave. It's the first time I know that you've given evidence to our committee. Just before we start on the questions, we just have to do some formalities declaring interests. I'm a non-practising barrister, former consultant to a law firm, and for today's purpose I might add that the joint head of my old chambers is Brian Altman KC, who of course carried out a review of the SFO that we may refer to in the course of the evidence. Mr. Timpson?
I'm a barrister with a current practising certificate but not undertaking any direct court work. I'm a former Solicitor General, former chair of CAFCAS, former chair of the National Child Safeguarding Practice Review Panel. My brother is chair of the Prison Reform Trust, and I'm advising ministers on family justice policy.
I'm a barrister who doesn't practice anymore, and I have a brother and a sister, sister and a brother-in-law who are also barristers as well, but they practice.
Okay, and then when Dr. Mullen joined us, he doesn't have any relevant declarations, so we won't interrupt for that. Okay, well, Mr. Ephgrave, how are you finding it now? You've been in post for some months. It's a departure from your mainstream police work, isn't it?
It is. Firstly, can I thank the committee for hearing my evidence today. I'm delighted to be in front of you. So far, it's 7 months since I started, and you're quite right. I've spent the previous 34 or so years in the police service, mainly in the Metropolitan Police, but I did serve in Surrey as well. And so my appointment as the Director of the Serious Fraud Office is a bit of a break with tradition in terms of previous incumbents. But the first 7 months have been busy, as you might expect, but very energising. And I must say I found the reception fantastic. I mean, everyone seems very pleased that they've got a new director. They seem very energised about the direction of travel we're moving in, and they've made me feel very welcome. And in the short time I've been there, I must say I've been bowled over by their dedication, their expertise, their specialism, and their sort of passion for what they do. So a positive start from my perspective.
Well, we'll drill down into some of the detail. I'm glad to hear that. I'm grateful for your team who met us at the SFO's office yesterday. But, I mean, there was some comment about having a non-lawyer as the head of what is a prosecuting body. What is it, do you think, that you bring to the task from that different background? What's the unique selling point that you can bring as director?
Well, I would say that one of the main challenges as a director of the SFO is to run the organisation. So it is absolutely a prosecuting agency. It's also an investigative agency, so it has both of those functions. I've known a lot about investigation. I've done a lot of that in my police career. I've obviously worked very closely with the CPS and the DPP in particular in the last 10 years or so of my police service. So I have some understanding of the prosecutorial process from that experience. But primarily, over and above that, I think the challenge with the SFO is to take the organisation forward, to make sure it's run efficiently and effectively, to introduce new techniques and tactics, to set the strategic direction, to make sure the workforce are properly engaged and supported, and all of the sorts of things that any organisation requires. And I think I have lots of experience of doing that.
During your, what I know is a very distinguished police career, did you have much dealing to do with fraud and what we might broadly term white-collar economic crime?
No, my speciality was homicide, guns and drugs when I was doing investigative work. That was where I spent my sort of investigative years, really. But I did have responsibility as Assistant Commissioner for all of serious and organised crime in the Met, which did include our economic crime team. So I sort of had oversight of the work they did, but no direct involvement by that stage.
Okay. So what was it that made you think you go move into this organisation, which is quite niche in terms of what it investigates?
Well, the first thing is, I mean, it could not be more important. When you think about this country and you think about our reputation as a global centre for financing, if you think about the millions of people that live here that trust and invest their money with people that do that as a business, I think we have to have confidence that those things are safe things to do. And I think my job is to protect this country's reputation and to protect taxpayers up and down the country from being ripped off in the serious and complex end of the spectrum. So the mission was really attractive to me. The fact that it's both a prosecutorial and an investigative agency was also very attractive. I mentioned earlier that I worked very closely with the former DPP, Sir Max Hill, and that gave me a real sort of insight into the decision-making processes that he was going through, and the idea of being able to combine responsibility for investigating together with responsibility for prosecuting was just irresistible.
When SFO was set up, there was a little controversy, I think largely it's not been a problem, but there's some controversy about the idea of having both investigators and prosecutors in one body in terms of ensuring prosecutorial independence.
Yeah.
Now, it might be argued that having a senior lawyer doing the director's role was a safeguard of prosecutorial independence. How would you counter that now that you've got, as was described by one commentator, a cop in charge of the SFO?
Well, it's important to remember the Roskill model, as you've mentioned, is a combination of different disciplines. So we have a very significant cadre of lawyers in the SFO. That's very, very important. And chief lawyer is my general counsel. So I have extremely good strategic legal advice from general counsel. And I think that role performs the function you've described. It sort of puts a safeguard around what you might worry about my instincts as a former police officer. And the lawyers that work to general counsel across the case teams provide day-to-day practical legal advice on the investigation and the preparation for trial. So I do think there are a number of safeguards built in. And of course, don't forget we also, when we get close to charge or post-charge, we'll be employing independent barristers from the bar who will, again, pass their own judgments around the strengths and weaknesses of what we're proposing and will highlight issues they think may become challengeable. So I think there's a number of sort of stages of safeguarding that are built into the way we work.
And the Sarah Lawson case that you saw, General Counsel been there for a while.
Yes.
And then the benefits of having somebody from a police background, I think you've set out. But you said you wanted to be, I think, the way I read it was bolder,
Yes.
More proactive.
Yes.
Is that sort of more breaking down of doors, or what? Yeah, it is. Okay.
I mean, that's a very kind of, I suppose it's a useful term to describe a state of mind.
Yeah.
I think one of the things that I learned from policing is that often the best policy is to take action rather than prevaricate. And I'm not suggesting for 1 minute that my predecessors, any of them, have prevaricated, but I just think I bring a sense of urgency and immediacy to the work that I do. I've always had that sort of inclination, I suppose. And if you put that together with a fairly deep knowledge of tactics that have been employed against serious and organised crime in other spheres, I think you bring those two things together and apply it to the work the SFO does. And I think you can add another element to what the SFO already has in its armoury. And I think I'm very keen to see where that can take us, because behind that is my desire to progress through our cases more quickly.
Yep, no.
There have been many examples where our cases have taken many years, and sometimes that's right for various reasons. But actually, the more that we can do to accelerate the process and bring a prosecution more quickly is going to benefit the victims primarily, but also the state, and also arguably those that are accused.
In the same speech that you talked about being bolder and more proactive, you also used the phrase that struck me, more pragmatic.
Yes.
Now, what does that mean in practice?
Well, if I go back to this point about trying to make cases proceed more quickly, one of the fallback, or one of the challenges I think with SFO work is because it's so complex, because it's so broad-reaching. Temptation is to extend the parameters of the investigation further and further as you get more and more material. And so what could start off as a fairly focused investigation against one or two individuals for a specific thing, if you're not very careful and you don't apply very, very strict discipline to your parameters, can soon become a much broader and much more complicated and possibly less provable set of cases. So the pragmatism point is about understanding that you can't boil the ocean necessarily every time, and when we set out our investigation plan, we should be really clear about what it is we're trying to achieve and keep reminding ourselves about that through regular reviews, peer reviews, and intrusive sort of reviewing of where the investigation's got to. And that might mean making decisions earlier in a case that actually we're taking the wrong turn here, or even that actually it doesn't look like this is going to develop into a prosecution. And so far better to stop, because I can then redeploy the resources I'm using against a case that may go further.
Okay, I get that. I mean, it's fair to say, isn't it, that then some of the recent past has been a bit checkered for the SFO in terms of its outcomes and some of the publicity that's stemmed from that. I mean, what lessons do you take away from what went wrong with, say, the Serco and New Royal cases?
Well, without speaking about specific cases, I think you're absolutely right. There have been high-profile cases which haven't gone the way we'd want. And, of course, some of those are talked about and discussed in the Altman review, which you briefly referenced, together with the separate review by Sir David Calvert-Smith. Both of those reviews found that the SFO had historical issues with understanding how to discharge its disclosure function. And that is an issue that is particularly difficult for the SFO because of the volume of material that many of our cases generate. And the ones you referenced, the very large corporate ones, often have larger than average volumes of material. And so it is an awful lot to ask of an investigative team to be able to keep on top of the disclosure practice and understand exactly where they should be going with that through a very long and complicated prosecution. And we learnt the lessons from that. Many of the recommendations in both of those reviews, 29 of them, dealt with issues around disclosure. So we've done a lot to try and address, my predecessors actually, and I'm carrying on their work, have done a lot to address the recommendations, which we have now met. But that work doesn't finish, So understanding how to deal with disclosure with large volumes is one thing. Allied to that, I think, is the pragmatism point. Arguably, we may have done better if we'd have contracted the investigations down at an earlier stage. I don't know, this is rather speculative, but keeping a focus on what it is you're trying to achieve, I think, is something else that we've picked up from those experiences.
The Altman review, and I think also Calvert-Smith's, David Calvert-Smith's review, both talked about the importance of embedding the right culture and practices. As I think in Mr. Altman's review case, it ought to become business, it need to demonstrate that it's become business as usual.
Yes.
Now in 2023, the Chief Inspector of Prosecution Services said it was too early to say if that yet had happened. What assurance can you give us now as to progress around embedding the recommendations of Altman and Calvert-Smith?
Well, the first thing to say is perhaps repeat the point that we have now implemented the 29 recommendations across both reviews. So we've
operationally implemented.
Yes. Yeah. We've put in place the measures that were suggested during those recommendations, much of which is to do with formalising the guidance and training we give to our disclosure officers, creating a specialist role of disclosure officers, making sure they're properly supported. But we've also added to that, so we are currently looking at how we can use technology to further assist the disclosure process to increase its accuracy and its speed. We're bringing in disclosure strategy documents, which are a way an investigator can describe the approach they're taking to disclosure. We're talking about disclosure strategy earlier in the case process with both the judge in the case once we've got an allocation and the defence teams where appropriate. So there's rarely a day goes past in the office where we don't discuss in one format or another disclosure. One other thing perhaps to say, we have a dedicated disclosure working group that's chaired by a senior lawyer, and that brings together practitioners from right across the office, and they meet on a monthly basis to go through best practice, hints and tips, etc., etc. And finally, just to sort of finish off, we have our operational handbook, which is the manual by which it's really our sort of doctrine, or which we expect people to follow, and that has a completely reworked chapter on how to approach the role of disclosure officer.
That's helpful. The other interesting point in the Calvert-Smith recommendation, I think in particular, was an oversight mechanism with the Attorney General's office in relation to what Sir David described as high-risk SFO cases. I mean, what did you take you as meaning by those sort of cases, and what sort of mechanism is there?
So that's a really reasonably broad term, but cases, I suppose, that have risks associated either with the reputational issues with the SFO, to fail would be seen to be a very bad thing, or potentially would not bring justice to many thousands of victims, for example, or there might be a large amount of money involved, potentially. So for any of those reasons might make something high risk or particularly symbolic, and those cases are taken by me to the law officers. We meet 3 times a year at a superintendent's board where the high risk cases or the emblematic case, symbolic cases are discussed, and I'm asked difficult questions by the law officers about the progress and what my strategies might be to deal with whatever the risk might be. And they're very helpful because they focus our minds on, one tries to anticipate what the law officers will ask, and it helps you get a grip on what issues in the case need to be addressed.
Do you meet with the law officers outside those superintendents' meetings? You do?
Yeah, so we have the those superintendents' meetings which are about casework, but we also have a strategic meeting with the law officers that talks more generally about the state of the SFO, our progress against our performance objectives, our people, our culture, that kind of thing.
Thank you, Chair. I'm just going to ask a few questions about the issue about funding of the organisation, and also obviously linked with that the issue of recruitment and retention of staff, because I think it goes without saying that the more good staff that you have, the better the organisation is. So can I just start off by asking the sort of slightly unusual funding model that the SFO has, in that your core budget is supplemented by additional blockbuster funding for high-value cases. Could you just explain to us what that means? And it's been rising over the last 5 years. Do you firstly explain what that funding system is? And then secondly, do you think it's good for your... does it help or hinder your strategy for the SFO?
Well, thank you for the question. The funding model it's not hugely complicated, but it has got some aspects which take a bit of explaining. So the vast bulk of our funding comes directly from Treasury as any other sort of government department. We get a block of money, that most of which we spend on salaries for staff. That's where most of our money goes, like any kind of people-centred organisation. But because of the nature of the SFO work, because on occasion we take on some very, very significant defendants, maybe large corporations with incredibly deep pockets, with much resource to draw on if they need to fight a case, which may take longer than our average case to progress, because they may be international elements, they usually are. We may need to go to other jurisdictions and so on. Yes. In cases like that, which are hard to predict when they're going to come, there has to be what you might call a pressure release valve that allows us to access funding to deal with that case. And that's what you're referring to, I think. So if any single case that we have, its running costs exceed a certain percentage of our total budget, we're allowed to access additional funding from the Treasury to help us manage that case. It's not used all of the time. It's used, on a needs must basis, but it's an important mechanism to ensure that we're able to do the work we need to do without worrying about running out of money to pursue a prosecution when it's in the public interest to do that.
So would you say that model is good for your organisation, or do you think it has problems?
Well, I'm only 7 months into the role. I'm not aware of any problems with it. It seems to operate the way it should. So we have been able to access funding when we've needed to. I mean, whether I would ever rule out a review, of course not. But at the moment, it does what it's designed to do, which is provide us with that sort of release valve if we need it.
Leading on from there, when you appeared before the Home Affairs Select Committee, you were asked about the funding and resources, and I note the chair said that you answered very carefully, said, I have a limited amount of resources. And there is, I think, an issue about resources. Do you feel that you do have enough funding to be able to carry out both part of the SF job, not just the prosecution, but the investigatory part as well?
Well, I think the first thing to say is I'm very confident we make the best use of the money we've got. I mean, we are really, really on it in terms of being efficient and effective, and we're really sort of focused on making sure we get the most benefit from the resourcing we have. I'm also, as a civil servant, well aware that the decisions around who gets what money is outside of my control. So what I can do is I can make the case to officials in Treasury and in Parliament generally about why they might want to give the SFO additional funding, and it's a matter for them whether or not that outweighs other considerations they have to make. But, we are a small organisation. We're about 600 or so people strong. So we have to be very careful about which investigations we take on. We can't take on every investigation we might want to. So we have to make some tough decisions sometimes about which investigation we go with, because there'll come a point when we run out of capability, of course, like any organisation, frankly.
Thank you. Now, I understand that previously you've said that the SFO needs more staff, and there is a quite a high turnover rate, as well as the fact that you need additional staff. And I believe in the Financial Times reported in November of last year that you said that recruiting the new staff was going well, and that in the year 2023-24 that you'd been able to offer about 100 people the jobs. Yeah. Have they taken them up?
Yeah, so good news on that front. So when I talk about more people, I was talking about filling vacancies we had. So this wasn't about the overall envelope of staff or posts that we had. We just didn't have people in the posts that we were given. So we've done very well, I think. When I took over in September of last year, our vacancy rate was around about, I forget the exact figure, 23 or 24% vacancy rate. So a significant number of empty seats. We're going to finish this year on about 50, again, it's approximately about 15% vacancy rate. So we are improving quite significantly. And our attrition rate, so the rate at which we lose people, is stabilising at about 16%, which is slightly higher than I would want, but it's still not unmanageable. And we're, at the moment, our recruitment rate is outpacing our attrition rate. Now, there'll come a point where that balances off. But we are still, keen to fill all of the seats that we've got available.
What about in relation to, you talk about the attrition rate, but what about the retention rate? Because one of your predecessors, Lisa Osafsky, said to the Public Accounts Committee in February 2022, that one of the problems you have is retaining the best and the brightest, because they can just walk across the street, I think she said, to something like Price Waterhouse or KPMG's and get paid twice the money they're getting. Yeah. So, and I think that was also confirmed by the Altman and Calvin Smith review, where they found a very similar issue or a challenge. So how would you, I understand you seem very optimistic, but do you think therefore that your problems of retention have finished, or are they still going to be happening? And if so, what do you think can be done to help the SFO to retain their staff?
It's a great question. It's something we think about a lot, actually. I think the first thing to say is, I don't think there's anything wrong with a healthy attrition rate. I was recently in the States talking to the attorneys over there, and what is commonplace over there is not found so much in this country. And over there, it's very common. In fact, it's expected that particularly lawyers will go from private practice into the public arena, spend 3 or 4 years there. They'll go back to private practice, probably with an enhancement in their salary or their status, and they might come back again later on. So there's this kind of interplay between private and public practice. We do get that here, and we've got examples in my office, but it's not quite as mainstreamed as it is in the States. So I think there is something to be said for people coming to work with us, gaining experience, going back to the private sector, and then coming back again from a lawyer's point of view. I think that helps. But we need to make sure that we don't, that there's not excessive issues with attrition. When you talk about salaries, of course you're right. We in the public sector can't compete necessarily with private firms, but that's only a problem if money is the sole motivator. And I don't think for our people it is the sole it's obviously a consideration. We all have to pay the mortgage and so on and so forth. But I think there's more to the SFO than just what we pay. We offer, I think, a unique insight into a unique organisation. We are the only combined investigative and prosecutorial agency. So in terms of a career enhancement, it's a wonderful place to come. We do offer other sort of what you might call benefits, so inclusion into the broader civil service framework. We offer sort of the sense of, it sounds a bit corny, but we offer the sense of mission and purpose, which some private industries can't do. So I think a combination of factors makes us attractive, and it's not just about the money, but that doesn't mean to say I'm not practical. I do understand, people have got to get to work, they've got to pay their bills, they've got to, inflate, all that stuff. So of course we're always looking at how we can make the best offer to our people, not just our lawyers, but our investigators, our forensic scientists, our data scientists, and so on and so forth.
Can I just ask, the people that you recruited, about the 100 or so, in which, are they lawyers, investigators, or who, how's the balance of set out, 40, 50s?
Well, the majority of our recent recruits have been investigators at various levels, so junior to senior, but we've also been actively recruiting lawyers, so we've been doing both, but we have slightly more. We have more investigators than we have lawyers, so proportionately we're going to always be recruiting more investigators than lawyers. But the lawyers are a very important part of our recruitment campaign, and we're pleased to say that we have been bringing lawyers in as well as we've been bringing in investigators. So that's very positive from our point of view. I might add actually that, just in case it helps, I do meet with every single new joiner and have done since September, and it's 2 or 3 a week. I struggle sometimes to fit them in. But the thing that comes across is this point about, I always say to them, why on earth have you come to join us then? What is it about this organisation that makes you want to come here? Which is back to my point about motivation. And I know they're talking to me, so they might be saying what they think I want to hear. But I think I can see through it. And they genuinely are fascinated by being part of it. They say how wonderful it is to be with us. And, I just keep my fingers crossed they feel like that in 6 months' time. And that's my job, to make them feel like that in 6 months' time. But they come in with a really strong sense of purpose and commitment. And yes, money's an issue, but it's not just about that, I guess, is what I'm saying.
Just a sort of final question from me. To what extent those people who are interested, say, working for the SFO or in that kind of work, who are interested in a career investigating fraud, to access relevant courses and training? Is there anything available for them? Or?
Yes. So one of the things that came out of some of the reviews that we've done and our own internal sort of assessments of how we can make a better offer to our employees is to see whether we can create a sort of real culture of continuous professional development within the organisation. And there's a number of internal courses that we've laid on. So, for example, we have a sort of initial investigators programme. In fact, they're running at the moment in our office. In fact, Sir Bob, when you came to see with Edward & Co, you might have seen a classroom opposite that was full of people. But those were our people being taught how to investigate by ex-Scotland Yard detectives. So that's one example of an in-house development course we put on. We also purchase courses from the College of Policing around disclosure and other specialist courses. And things like data science and forensic data manipulation. All of these kind of niche subjects are also catered for. We're not where we would want to be. I mean, it's relatively early days, but I think we put a lot of energy into designing something which is an attractive proposition for someone that's relatively inexperienced. They might want to come to us and think, crikey, I can do all these different courses, and in 5 years, I'm going to be a much more professional and qualified individual than I am now. And that's another draw factor for us, I think.
Thank you so much for that.
Thanks. You made the point, Director, that money's not everything, but you talked in terms of a fair remuneration for your staff. So I suppose reasonable remuneration for work reasonably done is part of it, isn't it?
Yes.
And can I then take you to a specific point in one of Mr. Ortman, Casey's recommendations? Because Mr. Ortman, of course, for context, is former senior Treasury counsel at the Central Criminal Court, a very experienced prosecutor. And one of his specific recommendations was that the remuneration for disclosure reviewers, key part of the disclosure system, was not reasonable remuneration for the work done or expected to be done, and should be increased to come into line with that of the other government agencies. Now, your predecessors' watch, the SFO reported that they thought about that, but concluded it wasn't possible to make the savings to do that. But that seems to go at odds with your legitimate philosophy of reasonable pay for work reasonably done. Is that an issue that you're going to be reviewing?
All of our pay and remuneration policies are kept in under review. One thing to mention perhaps is that there are limits to how much we can offer as a day rate to people from private practice to come and work for us to do disclosure reviewing, and we are at that limit, so it's hard for us to move beyond that.
What sets the limits, Director?
It's a centrally set limit. I'm not sure what the mechanism is.
But centrally set by who?
Treasury, I assume.
The Treasury, I see. So as contractors, in effect, is the way they look at it, or?
I don't quite know how they look at it. I just know that there's an amount beyond which we can't go.
You might be helpful if you could let us know how that system works, because it might be a case. Have you thought about, given the centrality of disclosure to your work, and how failure of disclosure has been central to some of the less successful parts of the organisation in the past?
Yeah.
Is that the case where you might be wanting to go back to Treasury and say, look, ensuring that we're competitive in disclosure reviewers is critical to our business case?
We have reviewed the rates we pay our lawyers that do disclosure, but of course it's not just lawyers that perform that function. We employ non-lawyers to do a lot of disclosure work as well. So absolutely we'll keep it under review.
Okay, thank you. Mr. Timpson.
Thank you, Chair. Can I take you back to the issue of case progression, which is at the heart of trying to manage the organisation effectively and efficiently, beyond having the funding that you require, having great people working in the organisation. Time is probably one of the most precious commodities that you have available to you in your organisation. And you've already touched on how, in your words, the SFO will be faster when it comes to case progression. And you also suggested that you will find new ways of trying to achieve this, including, to quote you, investigative techniques that are commonplace elsewhere. Could you just give a little bit more insight as to what are those techniques that you're alluding to, and why weren't they being used previously?
Sure. Well, I didn't mean to suggest that the SFO has never used covert tactics, and it probably would be inappropriate for me to describe in any great detail what they might be, but generally I'm talking about taking the approach that many police forces will take when a crime is being committed, a crime in action. So interceding, perhaps using an undercover police officer, perhaps using intrusive surveillance techniques. Those kinds of things are widely used, as everybody knows, in policing, and I think there's a place for them in some of the work that we do. Not every case would be amenable to that, but there will be cases in our case though that would possibly be. The benefit of that is it takes you to the evidence more quickly. It gives you direct evidence if you get it right about who said what when and what's going on, and that will allow you to get to the sort of the main point more swiftly. So back to my kind of contracting the time frame between opening an investigation and perhaps reaching a charging decision. That's not the only way we might do that, though, if I may expand. I mean, one of the other things that I'm very keen on thinking about, and I mentioned it at the Rusi speech you've referenced already, Sir Bob, is whether or not in this country we should think about our policy regarding whistleblowing more generally, and whether or not there are lessons to be learned from other countries where there's incentivisation for whistleblowers, because once again that provides a legitimate shortcut to where the evidence can be found. If someone who knows what's happened is willing to tell you how it happened and who did it and so on, and where the evidence might be located, it will significantly shorten our investigative practice, because it will take us straight to the important material. So that's something which I'm keen to explore and see what might be possible. And I've mentioned that a couple of times previously.
I believe the Department for Business and Trade are doing a review of the whistleblowing framework, which maybe provides an opportunity for the SFO to contribute to that and make the case just made to the committee. Yeah. But why do you think, although the powers have existed, the SFO through the Serious Organised Crime and Police Act 2005, not been used, or perhaps has been used reluctantly in the past?
Well, there is a difference between, of course, whistleblowers and people that might be able to access the Serious Organised Crime Police Act provisions, which are primarily for offenders. So people who are suspected of offending can enter into written agreement with a prosecutor to provide evidence in exchange for a reduced sentence potentially. So that's what SOCPA allows for in broad terms. Whistleblowing can come from people who are directly implicated, but it also come from people who've got no criminal involvement at all, just happen to know what's happened. So I think there's a distinction to be drawn between those two. But in answer to your question about SOCPA, it's not just the SFO that hasn't used those powers particularly, they've not been used significantly at all, I think, really, in this country. So it's definitely worthy of consideration.
You mentioned you've been to the United States to perhaps compare notes and understand what they do differently. And this would seem to be an area where they do have a different type of approach, where the use of whistleblowers, where they're assisting offenders, able to offer immunity from prosecution or reduce their sentence, wherever it may be. So what is it that you think we would need to do to establish a similar type of approach in this country that is maybe culturally acceptable as well as works in practice?
Well, I think if I could talk about whistleblowers who are not criminally culpable, perhaps as one group of individuals. So these might be people in an organisation or a corporation that see wrongdoing and feel uncomfortable about it, but feel slightly caught about what they should do. Morally, they probably feel they ought to point this out, but practically they probably understand that if they were to do that, they may suffer reputationally, they may struggle to get another job in the same profession, they may lose some of the benefits of their lifestyle. So it's a lot to ask somebody. The incentivisation of a whistleblower effectively if it's done correctly, would provide a degree of insurance for people in that situation, that if they were to blow the whistle and effectively put their lifestyle in the balance, should there be a successful prosecution and outcome, there's going to be some recompense at the end of it, which allows them not to effectively lose everything. The example I'll give comes from America, actually, and it's quite an interesting statistic. I think if you take 2022 as the year, something like $2.2 billion worth of fines and judgments were handed down. I think 86% of those originated from whistleblowers. Big proportion is what I'm trying to say. In this country, in the SFO, in the last financial year, only 5% of our referrals came from whistleblowing. So there's a very, very significant difference between the contribution whistleblowers make in the States, whether you like their system or not, and the contribution they make here. All I'm articulating is the desire to understand what we might learn from that, given that we have a different context, given that we have a slightly different sentencing regime and so on, how we could find a similar way of incentivising whistleblowing in this country that's acceptable to this country, but delivers the benefits that the states have clearly got from it.
I believe there's only 2 organisations in the UK that offer incentives or financial reward for whistleblowing. One's the Competition Markets Authority around illegal cartels, that type of thing,
yes,
as well as HMRC in relation to tax fraud.
Yeah.
Are they people that you may, similar to the US, go and compare notes with to see whether you could learn from how they've gone about establishing that as part of their way of trying to track down illegal activity?
I think that their setups are different to what I'm describing. I'm keen to effectively get involved if there's a debate to be had, and if there's a policy discussion to be had about the use of whistleblowing, then I would want the SFO to be in the middle of that, because I do think we can learn. I mean, whether the HMRC and the CMA schemes are compatible with what I've talked about, I'm not able to say.
And just finally, on the length of cases, I don't know whether you're able to tell us how many live cases you have at the moment, and also you have the asset recovery work on top of that.
Yeah.
You're able to share with us that would be helpful. But of course, the nature of the beast that you're trying to track down can lead to potential mission creep, being sent out of lots of blind alleys which waste up a considerable amount of time, effort and resource.
Yeah.
So how are you going to set a clear, acceptable time frame or how long a case should last from it being opened to getting an outcome, hopefully a successful outcome, an outcome which is less than the 4 years that we saw in the last strategy? And I'm not sure it's mentioned explicitly in the most recent strategy, which was published last month, the 2024 to 2029. Perhaps if you could tell us what is it that you expect now to happen in the SFO?
So central to my sort of strategic thinking is how do we contract, as I said before, the time from opening the investigation to a disposal. Now, of course, I can't guarantee a trial because we have the issues with backlogs in courts, but I'm talking about the time it takes us from when I say, yes, we're going to investigate this, to the time in which we say, right, you are charged with, or there's some other formal disposal. So that's the period of time I'm talking about, not conviction, because would have to then take into account court listing and so on, which is another thing altogether. My predecessor set a very ambitious target for the average case time from opening to disposal of 3 years. Now, we have adopted that target for this strategy, for the strategy you just described, the 5-year strategy we just published. So we're going to stick with the 3-year strategy. We're not at it at the moment. In fact, we're 50% over it. So our current average is about 4.5 years. But the thing I would say is that a couple of big cases because we deal with relatively few cases, 2 or 3 big cases, and skew the average. The sort of light at the end of the tunnel, if you like, is perhaps the cases we've taken on since I started. We've opened 5 new investigations since I started, and I'm looking at those particularly to see what they can tell us about the speed through which we can progress, because they are not, if you just take them as a group, they wouldn't be affected obviously by historical 10-year cases, for example. Which isn't to say, by the way, I do need to make this clear, some cases must take longer and will take longer than 3 years. That's an average. I mean, if you're dealing with a very large and complicated multi-jurisdictional fraud with many component parts and lots of other jurisdictions to engage with. Just the process of gathering the information and getting the letters of request agreed and all of the protocols done can take a significant period of time. So we have to be thinking about averages rather than individual cases.
One last thing, just one supplementary final question. Just about the decision making on shutting down a case at an earlier stage, which you mentioned previously. Is that something which you found was already part of day-to-day work, as well as just the strategic planning of the SFO, or is this something you're going to have to instill? Because there will be some people who work in your organisation who have been perhaps on a case for a number of years. They poured their heart and soul into it. They're desperate to see it to a successful conclusion, but then you pull up the drawbridge. That might affect staff morale. They may feel that they're not valued. Those things that you're trying to address as you sort of bear down on some of the case progression.
I mean, there's absolutely a tension there. You're quite right between making the right decision around strategically about whether or not the game is worth the candle, and whether the use of public funds and valuable resource to pursue an ever diminishing prospect of a conviction is actually sensible. Together, you've got to balance that with the years of effort that individuals maybe have put into that case, and understand that for them, it's everything to them. They might only have been on one case since they've been in the SFO. That's a really difficult message to get across, which is why early and regular reviews of cases from day one is important, so that people are always on notice that rather than the presumption this case will always continue unless there's a reason to stop, the presumption will be this case will stop unless there's a reason to continue. And if you take it from that position, if you look at it through that end of the telescope, then people from the very get-go know that they need to be persuading us each 6 months that this case has got some life in it. Otherwise it's dead in the water and we're going to stop because we need to use that resource somewhere else. So it's getting you're absolutely right to highlight the tension. Of course there's going to be tension there, and I'm not pretending there aren't people in the organisation that will be bitterly disappointed if one of our longer running cases is not proceeded with. It's my job to try and keep them on board and persuade them of the sense strategically, looking at public money, looking at valuable resource, looking at what other benefit we can do with the money or the resource that we're currently using on this job, and try and persuade them that actually all is not lost. Use that passion you've got and let's deploy it against somebody else, that we've got a better chance of convicting.
Thank you. Thanks very much. I was interested in learning from the States. And the Economic Crime Act, you might say, builds on some of that with the identification principles, failure to prevent offences. But in relation to the use of whistleblowers and other things, would it be fair to say from your own examination of American models that their prosecutorial approach frequently seems to be very much geared to driving a guilty plea rather than preparing for trial? Now, is that something that you envisage as an area that you might want to learn from?
It's certainly striking. I spent time with the prosecuting agencies in New York City and Washington, and in both places it was absolutely clear that from the outset of an investigation, the mindset is, where is the early guilty plea coming from? Because an early guilty plea means a cooperating witness, means that the evidence is identified directly. We have someone that can testify against those that they say are culpable, and it brings us to a position more quickly where pressure can be put upon those that are still being investigated to effectively accept that the game's up, and they may as well plead guilty, because actually it's clear that if it goes to trial, it's very unlikely that they will escape with an acquittal. That doesn't mean to say they don't have a contested trials, of course they do, but they have a much higher early guilty plea rate, and I think they approach the process from that mindset, always accepting that if it doesn't work, we've got to be able to go to a contested trial, but we want to try and drive towards an early guilty plea because it's effective and efficient from time and money point of view. You have to have safeguards, of course. We don't want to get in a place where justice is not done or there's injustice and people are perhaps threatened or terrified of a sentence and therefore plead guilty when they haven't. I mean, that's anathema to them as it is to us. Compare and contrast the approach in this country. I think what I've seen here, both in my police career and here, is that we approach an investigation from the place that this will be a contested trial, and so we sort of adopt a mindset that takes to that outcome. And I think there's something to be learned from the American model, which isn't to say we should adopt it lock, stock and barrel. There's big differences. Of course, the sentencing regime in the States, for a start, is a very significantly different thing to what we have here. But there are lessons to be learned from looking at how can we progress this case in the most effective and efficient way. And if there is an individual who we've got a lot of evidence against that might be willing to talk to us in exchange for a reduced sentence, and I think we should look for those opportunities because they will allow us to get justice more quickly.
There's also a suggestion raised, I think you raised, of financial incentives for whistleblowers.
Well, I must draw the distinction between people who are guilty of criminal acts,
yes,
who are cooperating under SOCPA.
You wouldn't think it appropriate to give any financial inducements for those, of course. No.
That's entirely governed by the SOCPA. Whistleblowers, when I talk about whistleblowers, what I'm meaning, and it's my own sort of, I should have been clearer, what I mean is people who are not culpable of criminal acts,
indeed, yeah,
but know that something wrong has happened and
exactly
want to talk
right,
to someone about.
Yeah.
Those people, I think there is an argument to be said that supports providing some form of financial safety net for them.
Are you alert, though, to the cultural risk with juries? That if I was defending, I might have some fun taking the witness through how much they were paid to give evidence against my client, making the point that the evidence is tainted. Is that a risk? How do you deal with that?
Well, I think the way it might work, and this is speculative, really, I suppose, but I'm not suggesting that there's a payment made. What I'm talking about is that at the end of if somebody or a company, let's say a company is convicted of whatever it might be, and a fine is handed down, then a percentage of the fine may be provided to the person that created that conviction, allowed that conviction. So it's more of a sort of it has to be a successful outcome, and there's no guarantees, and that provides a degree of safeguard to the jury proposition that, well, you paid this person, so they're going to say what you want them to say.
Well, it's going to be an interesting debate, isn't it?
It will be.
Dr. Monk.
Thank you. Hello, Mr. Ephgrave. Apologies I couldn't be here for the start of the session. I just wanted to ask you some questions now around data handling and disclosure. Obviously, the context is there has been some unfortunate cases at the SFO where disclosure issues have led to the collapse of potentially important prosecutions. I just wondered if you might first, just for the record, really outline why accept are some real challenges for the SFO when it comes to disclosure in your investigations.
Sure. Well, disclosure is a very challenging subject for the SFO, mainly because the legislation that was drafted back in 96, Criminal Procedure Investigations Act 96, sets out the duties of the prosecutor, and it makes it really, really clear that the prosecutor must retain and record all unused material. So when you start an investigation, whatever the investigation might be, you start to gather material, and the law says that all of the material you gather has to be retained and recorded, and then reviewed. And if it meets a certain test, has to be revealed to the defence. That's what we call the disclosure test. Does it either support the prosecution, support the defence as you understand it to be, or does it undermine the case as you're putting forward? So in any investigation, particularly these days with digital sort of media, that's quite a big task. But for the SFO, it's a monumental task. To give you some sense of scale, the biggest case on our books currently has got 48 million documents associated with it, which is 6.5 terabytes of data, if you can imagine that. I mean, I dread to think how high it would be if you piled it up on A4. That's not the average, that's an outlier. Our average is about 4.5 million documents broadly. So that's still a huge challenge. And we have invested over the years in document management systems whereby we lodge these vast volumes of material and we review them electronically. So they're not pieces of paper anymore. They are on a screen, but you still have to read them. You still have to go through them. You still have to make decisions. And associated with all of that is the sort of the logistics behind it, which is all of that material has to be scheduled so that we can provide it to the court and the defence. And just scheduling 4.8 million documents describing each item, what it is on a schedule, can take months. So, and of course, when you're dealing with that many, you need to get it right every single time. And, if you've got 100 documents, that's difficult enough. If you've got 4.8 million, it's a significant challenge. So it is problematic for us. We do spend about 25% of our entire operational budget doing disclosure, which is a significant chunk. That's why we're so interested in what Jonathan Fisher is doing with his review of disclosure, and we've made some suggestions to his team about how things might be changed to help the work of the SFO.
I'll come on to that, but first I just wondered if you could share your reflections following the inspection.
Yeah.
I think it highlighted cases where you've done it really well and cases where you hadn't done so well. What have been your key learnings from those?
I think probably that disclosure starts the minute you start an investigation. It's not something, an exercise you embark on at the point at which you charge. You have to be thinking disclosure from the very beginning, and you have to be documenting what you think. You have to be saying, this is what I'm doing in terms of disclosure, and this is why, so that information can be shared at various stages with both the judge in the case when it comes to it, the prosecuting counsel when they get appointed, but also the defence team, so that everybody is clear about what decisions you've made strategically along the way. And that's actually fun enough. I don't want to jump ahead, but that's one of the things we're keen to do is to have earlier defence engagement so that we can agree terms at an earlier point in the process, so there's less chance of last-minute requests for disclosure.
Just unpick that slightly. Would you say then the cases where it's led to a failure of prosecution in the end, is it because there's some really important bit of information that's fundamental to your prosecution that they haven't had, or is it because you just haven't been able to justify and explain why you've done what you have with information that you held?
I would say it's the latter. Let me explain. So I know everybody knows this, but it's probably worth setting out. So when we put a case, we provide the evidence. That's what we rely on to prove the case. The documents that show so and so did something, or the money went here. So the evidence is provided in its entirety. That's what we're building our case on. What you've got left over, the millions of stuff, is all the unused material. So we're not using that to prove a case. But the duty we have is to make sure we look through it all, to make sure there's nothing in there that either cuts underneath our case or supports it. So it's unlikely that we've missed something that we're going to need to prosecute, but it's also probably unlikely we've missed something that's so blindingly obvious, the exculpatory, that we wouldn't have prosecuted in the first place. So it's generally speaking a failure of process, which isn't to say it's not possible that an important document's been missed, but it's unlikely because it's unused material. It's stuff we've been through, we say is not really of any value to us or to you.
When I think about these things, I guess I contrast it to an ordinary police investigation where we don't expect the police to fingertip search every possible crime scene to find some micromillimetre of DNA that might belong to someone else who could have been at the scene. We just expect people to put kind of a reasonable best effort in and accept that there's no investigation is perfect. I think the challenge here is you can't go back to the crime scene and prove that you missed something. Also in these types of cases, it's just all there in black and white, and someone can find something and show that you missed it. It doesn't mean necessarily that a fair and proportionate effort hasn't gone into making it so it's a fair fight, so to speak, in the court. I find that it's a bit of a jarring contrast between an ordinary investigation, what we expect officers to do and prosecutors to do, compared to this particular issue.
Yeah. I think that one of the problems the SFO has, which makes it more difficult, is that we do generate an awful lot of documentary material, which is different, to pieces of DNA or fingerprints, or physical items. There's usually a handful of these sorts of things. For us, as I said, it's mainly documentary evidence, and once you've got it, you can't unget it. So once you've got it on your system, you may have seized it because you think it might be valuable. It turns out it's not valuable, but you've got it then. You can't get rid of it again. You're then required to go through the process that's dictated by the CPIA, and that's, I suppose, one of the sort of things we're really focusing on to try and minimise the burden of disclosures, to make sure we don't seize that material which we do not need. So it's being more focused, and particularly with electronic devices. Actually, when we go and search someone's house, perhaps we're looking for electronic media that might have documents on. I think the average number of digital items any one person in this country has got at this moment in time is 7. You may have more or less than that. I have less than that because I'm not interested. But because it can be a TV, it can be a smartphone, and you name it. I think the practice until fairly recently was that, well, we don't know what's any of this stuff, so we're going to have to bring it all back to the lab and then laboriously go through all that stuff to find out that actually only one of those items was at all relevant. What we can do now with use of some smart technology is to do some triaging at the scene. So actually we reduce the number of devices we bring back. So the trick is to reduce the amount, be really, really proportionate about what we seize, And so long as we record what we've seized and what we haven't seized and why, then I think we're in a defensible position, because the less material we have, the less material we have to
is back
review.
and then
Precisely.
to produce material that's helpful to them, rather than you to produce it just because you happen to be in possession of it, and there could be any number of other people in possession of it at the same time.
Exactly.
You touched on this. I just wonder if you want to add anything further in terms of what you might hope from the outcomes of the independent review. One element in particular that had occurred to me is the keys to the warehouse approach, that you just let people have whatever you've got, and if they find stuff, they find stuff. Two questions about that. One, would there be a burden on you? Does that material sometimes contain things that a third party, even in the defence, shouldn't see? And does that create a situation where it becomes unfair on defendants who don't have the resource to pay someone to go through? They would face the same challenges you face as defendants.
Exactly. I think it's often seen as a panacea, and it's a very attractive thing at first blush, but actually it's fraught with danger for some of the reasons you said. So firstly, you need to understand what's LPP material and what's not LPP material, so subject legal privilege and what's not. So you can't just hand everything over. Secondly, even if you wanted to hand everything over, according to the Data Protection Act, depending on who you're giving it to, you have to redact all that material, depending on who you're giving it to and which particular characteristics you need to exclude. So you still got to go through it all. You still got to, put the proverbial black marker pen through all the names and addresses and protected characteristics that are not relevant to that person you give. So a huge undertaking just to hand it over, and probably more fundamentally, actually. All you do is you put the burden onto a privately funded individual rather than a state prosecutor. So they've got to then go through the whole flipping lot. And if they can't afford a decent defence team or a big defence team, they may never achieve that. So not only will it not get done, but it probably will, if it does get done, will take an awful lot longer. So I think there are lots of issues with it. I'm not an expert, but I think that it is a difficult. It's not a solution that would appeal to me.
Okay. And are there any other elements that you haven't mentioned about how we think you could do it better? Because it just seems to me it's ridiculous. Not ridiculous, it's the situation as it is, but it's unhelpful that 25% of your budget is going on this work.
Well, I suppose I would say this, but I think disclosure is a really important element of a fair trial. We all know that, and it's really critical that we don't regress back to a place where the prosecution's allowed to just keep stuff and not bother, because that's just an injustice, isn't it? So we can't go there, but perhaps we can go somewhere which protects against that happening, but lessens the burden. And I think one of the things that we've asked for, a number of things we've asked for, the first thing is whether or not the definition of relevance could be reviewed by Jonathan Fisher. Now, without getting too technical, the CPIA, the legislation that governs disclosure, says what relevant, and what it says is that everything is relevant, everything that you've seized is relevant, unless you are sure it is incapable of having a bearing on the case. Now, when you've got an investigation such as the SFO has, where it might be 3 or 4 years in the making, how on earth do you know that a bank statement you've gathered today is going to be incapable in 3 years' time? You don't. Ergo, everything is relevant. So you get the big volumes. So I think you could narrow the definition of relevance to relevant to the case as charged, as opposed to relevant to the investigation more generally. That would narrow it to a degree. I think, secondly, we're very keen for there to be a better superintended engagement between defence and prosecution, so that we can sort of come together on things like search terms, what's in and out of scope. And that could significantly narrow the material that needs to be scrutinised. And I think that needs to be superintended by the judiciary in some way or other.
Because obviously otherwise, if it's not got some kind of independent chair, the easy thing for defence to do is say, well, we think it's all relevant actually, and you need to go through the whole thing.
That's right. And then, it might be a special hearing is convened, and both parties are then subject to a direction from the judge about how to proceed with, this element of disclosure, for example. And then perhaps, if that were to happen, there'd be a limitation on the number of late applications you can make under Section 8 for further disclosure, because actually, if you've all agreed already what the terms are, what are you doing coming along at the last minute? So the judge might have to be really persuaded to allow that, rather than forced to accept it as is the state. I was talking to I was in the lift, actually, one of my really good case controllers, they're all really good, by the way, it's a particularly good one, case controllers the other day, who was he was saying, it's the third day I haven't had a letter from a defence team. I said, how many did you get in a day? He says, I can get 10 sometimes. You know, not all in one case, but collectively across 2 or 3, 10 letters saying, we want this, we want that, we want the other. And they spend all their day servicing these things, and it just seems ludicrous. So I think there's some merit in that. And then we come to the redaction point I made, which is not strictly about disclosure, but it's the effect of well-meaning legislation on a practice we have to adopt. So how do you lessen the redaction burden? And that's something that I think is, you know, actively being considered at the moment.
The redaction burden is between which bodies that you're sending?
It's between, well, in mainstream law enforcement, it's between the police, the CPS, and the defendants. And for us, because we are effectively the police and the prosecution together, it's between us and the defendants' teams. Yeah.
All right.
When you have multiple defendants, of course, you're having to serve material on each of their firms, and of course you have to redact it in different ways.
Yes. Okay. Thank you.
Thank you very much. Mr. Timpson.
Thank you. So I was just having sort of flashbacks to a fraud case I did many years ago, spending a lot of time redacting things. Can I? You probably cottoned on to the fact that we've gone through your RUSI speech with a fine-tooth comb to establish what your leadership sort of priorities are. And one of the things that you touched on was what you termed technology-assisted review. We were talking a little bit about how you can use ways of being more efficient with the technology that you come into contact with. How much potential do you think this has? And could you just tell us a little bit more about what you think it will manifest itself in terms of day-to-day investigations?
Well, thank you. Well, I suppose what's behind what we call technology-assisted review is the use of machine learning. So this is a concept which people will be familiar with, and its use in criminal justice, or I should say in legal practice, is established in the civil side of the business. I'm told by solicitors that work in that area that they're familiar with kind of machine learning algorithm type stuff to review vast volumes of documentation. It's not really been used, as far as I'm aware, in the criminal side of the business. So we're looking at a system that we currently use as a document management system that has a machine learning facility within it. And what it does is when you are, let's say you have 1 million documents to review, and you've kind of put them into chunks to review, depending on search terms or whatever. Suppose you have a chunk of 10,000 documents you're reviewing for relevance. What we do at the moment is the reviewer will start at the top, and they'll work through document 1, document 2, document 3, document 4, in usually a chronological order until they get to the bottom, and then what comes out of it comes out of it. They have no idea whether the relevant material is going to be at the top, the middle, or the bottom. What the machine learning facility does is it learns so first you program it to start with saying what you're looking for in simplistic terms, and then it watches what you pick as a human, and it learns from that, and it constantly updates its understanding of what you're looking for. And all of the time that you're going through those documents one by one, it's constantly going through that pile of 10,000, and it's bringing documents that it thinks matches what you're looking for closer to the top. So the idea is you effectively find all of the material that's likely to be relevant in a much shorter time, to a much higher degree of accuracy. That's the goal. Where we are with it is we are piloting it on a live case at the moment. The early findings are encouraging, significantly encouraging, but clearly it's just quite a novel approach, and we need to make sure that primarily the judiciary are happy with our use of it, that the defence teams that are going to be working with us understand and are happy with it, and it can be proved to be reliable and fault-free and all of those things you'd expect. So we're taking each step as it comes, but the early indications are that it does provide efficiencies and reduces the time it will take to go through large volumes of material.
Could you help me out with what natural language processing is? I think I have the clue maybe in the name, but is that something you're also looking at potentially using?
You have the better of me there, I'm afraid. I don't know, but I can go and ask my people about that. It's not something I'm familiar with.
Okay. Well, I suppose therein lies part of the opportunity, but also the risk around technology, as much as it's moving at such a pace. You, as an organisation, will want to be able to utilise it as in as modern a way as possible that helps improve your ability to investigate a case with the minimum amount of resource, but with the maximum amount of outcome. But how are you with your future planning of what the organisation will need?
Yeah.
Are factoring that into things like funding bids, the makeup of the resource within the SFO, so that you don't miss what could be potentially something groundbreaking, how you can improve what you're able to do with the time, people and resources that you have.
Thank you. I mean, making the best use of technology and the tools that are available is one of the 4 pillars of our 5-year strategy. So we have an ambition that we will be ready and able to utilise technology the best way we can to improve our effectiveness and our efficiency. That's writ large in broad strategic terms. And then this year there's a number of business objectives that we want to achieve to take us a bit closer to that outcome. One of which is our targeted technology assisted review process we just talked about. But there's other things we're doing, looking at, for example, trying to procure a new case management system for the SFO. This is something that I think has been a long time coming. That will assist us greatly in ordering and processing the data and information more quickly and more reliably. And there's environmental scanning and looking at other opportunities we've got to learn from others. So there's a whole raft of things we're going to try and do this business year to take us closer to being truly able to exploit what technology can offer. But it does change all the time, you're quite right. And I think part of the trick is to keep watching what other people are doing. You can't invent it all yourself.
Where are we now? Last year now, the Economic Crime and Corporate Transparency Act was put on the statute book, which increases a number of powers that enable the SFO to investigate, including things like the failure to protect. And we're talking about really sort of serious economic crime here. As this is a new provision, provides you with perhaps a greater scope for intervening in a potential investigation. What are your plans as to how you will make the best use of what Parliament hopefully intended, which was to bring successful prosecutions in the future?
Well, it's a great question, and the ECTA, the Economic Crime Corporate Transparency Act, was a really important piece of legislation from our perspective because it did bring in, as you said, a number of measures that will help us. We're already using some of those provisions which are active now. So, for example, it extended the use of our Section 2 powers to allow us to require information from institutions and individuals in a broader range of cases. So I know we're using that actively as I speak. So that's allowed us to get information more quickly in cases where we wouldn't have been able to do that pre-investigation. So that's a really helpful provision. The change to the identification doctrine is a really important element for us. We haven't used this in anger yet, but it's a really important change, I think, because it allows us to be able to pursue corporates more easily where there's been a failing, but we can't pin it on the chief exec or somebody. Now there's a much simpler path to culpability for a corporation. So that's an important provision which we're keen to understand how to use best. And then the failure to prevent fraud is yet to be, I think there has to be code of practice published first before it becomes effective. But it's a very exciting provision. It kind of mirrors the duty to prevent bribery offence. It does only apply to large businesses at the moment, as we know, but still I'm very keen to understand how we can use that. Not just in the enforcement sphere, because again, part of our 5-year strategy talks about us understanding what role we have, if any, in preventing crime. And I think duty to prevent fraud is a piece of legislation that might help us prevent. Whilst it's not our statutory purpose, I think we can't just pretend that we have no part to play in it. I mean, least of all, we need to be a strong deterrent, and this legislation will help us do that. But equally, if we can help educate corporations on how best to behave, how best to regulate, alongside people like the FCA, then I think that's the space we should move into, resourcing allowing that, of course. So there's plenty of scope for sort of moving my organisation forward using some of the provisions that are in ECTA.
So take from that your intent is to try and, where it merited, to find a case and investigate which leads to a successful outcome by virtue of these extended powers.
Yes, I mean, I'm perhaps rather rather predictably, I want to be the first person the first organisation to take a prosecution forward based on the duty to prevent fraud, for example. That'd be a wonderful thing to do.
Okay, watch this space.
Okay.
Thank you.
We talked a lot about your RUSI speech because it was very helpful, very, very useful as a way of setting out a lot of your thoughts coming into office, Mr. Ephgrave. But final point I wanted to touch upon is you made the point in that speech that SFO cases have victims.
Yes.
And that those are often ordinary people, investors, or people who lost jobs when companies have collapsed, and so on. I think by the nature of it, you're probably dealing with victims on a greater scale in relation to an individual case than might normally be the case in a prosecution. What particular approaches do you need to take in dealing with your victims, given the number potentially in any case and the length of time your investigations take? What particular approaches do you do to make sure you meet your obligations under the Victims Code, for example, and so on?
Yeah, I mean, you're quite right. We do, our cases do involve large numbers of victims. I'll give you just a sense of scale. So if you just take the 5 investigations that we've opened since I started, together it totals approximately 50,000 victims in this country, broadly in this country, who've lost between them £300 million. So these are large numbers of victims. And of course the Victims Code is designed, quite rightly, on the basis that there's a kind of a personal relationship between an investigating officer and a victim, like there might be in a robbery or a burglary. Of course that is impracticable in the scale, but we do make provision for that. So the way we try and deal with that is there are obviously going to be individual victims who we will be dealing with, who may have lost, individuals who've lost an awful lot of money, or there might be an awful lot of people who've lost a relatively small amount of money that totals up. So we cater for both. We have a very well-regarded victim liaison team who work directly with our victims and our witnesses to make sure those, particularly that are giving evidence or somehow involved in ongoing prosecutions, are properly supported and kept updated. But for the broader range of victims who aren't directly involved in a prosecution but who have been the victim at some point of this fraudster we're taking to court, we have updates on our website regularly so that they can access that just through the internet and look at where their case has, or the case that involves them has got to. But of course the Victims Bill there's a fresh provision being drafted at the moment, I think, and we are engaged in consultation with the provisions that within it to make sure that the SFO is able to fulfil its obligations given our particular scale and the sort of the nature of our victims.
Okay. And how many in your victim liaison team? How many people have you got?
It's small. It's 3 or 4 people. I can't do that.
Yes, that's really. And is that adequate to deal with that?
Well, in terms of supporting people, primarily it's around providing that support for victims that are coming forward to provide evidence or witnesses. So the number of trials we have at any one time is small because of our cases. So they're able to cope with the practicalities and the logistics of looking after those individuals. And that's where we rely on the website for the broader reach across those many thousands of people that won't be coming into court.
Does that website enable victims to give feedback?
You know what? I don't know. I should know, shouldn't I? But I don't know.
Well, perhaps you could let us know. I just wondered if you had any other sort of feedback arrangements for victims.
Well, we do, of course, do victim impact statements. So we get good sense of the impact that a crime has had on a victim from those, and we routinely use those to demonstrate, the how victims have suffered, and they are very powerful documents. Actually, I was reading a variety of them fairly recently, and they are. If you ever wanted motivation for doing the job, they provide it, because these are people that have generally elderly people or later in life who have worked so hard all their lives, and all they want to do is provide for their family or their kids or their old parents or whatever it is. And all of a sudden, or they're looking forward to, some well-earned retirement enjoyment, and all of a sudden, it's gone. Yeah. And when you see what that does, it is very motivating.
Yeah. You talked about ensuring compliance with the revised Victims Code as an objective. Yes. Any other proposed changes or enhancements you're thinking of in relation to victims?
Other than the contributions we're making to the revisions, I don't think there are. No.
Fair enough. And so, a very useful session. We've covered quite a bit of ground, but you're 7 months into what I think is its 5-year term, renewable. I think touch wood. I'm sure it will. So, a bit of a way to go yet, but any further thoughts that we haven't touched upon about what your strategy is going to be over that 5 years or so period? Well, issues that you think you might have to contend with that we ought to be aware of?
I think resourcing is always going to be an issue, and we're keen to take whatever opportunities present themselves at spending review time to put forward a compelling case. I mean, one thing that I would say, wouldn't I, is that we offer great value for money. On the average, over the last 5 years, we've returned to the Treasury 3 times what it cost to run us. So if you're just looking at an investor save kind of argument, I think there's a strong argument for continuing to support the work of the SFO. I think the strategy is pretty bold and ambitious. It is a 5-year strategy, so it's going to take us a while to get there. But I do want the SFO to be world leaders, really, in the fight against corruption, bribery and fraud. And we have a good reputation now, so we're not starting from ground zero. I want to enhance that so that we are the real centre of excellence, and I think this country will benefit from that, and hopefully fewer people will become victims of crime as a result. That's the intention anyway.
Is there more that we could do to work on the international field stage?
Well, I'm putting a lot of effort into that, hence my trip to America to build some bridges there. And it's not all about going abroad. We do a lot of stuff through Teams and phone calls as well. But I think fostering good relations with our sister organisations in different jurisdictions is really important, because so often, if you want to get something done, it's much easier, isn't it, to pick the phone up to your counterpart in the FBI, for example, and say, look, I wonder if you can help with this. And often, without breaching protocols, it can often help things happen more quickly. So, there's that kind of informal network. But then there's the more formal stuff that we're getting. So the Home Office COPO initiative, which is all about an enhanced way of exchanging information, is a really important initiative which we're really keen to jump on top of. So there's plenty to be done in international space, but there's good routes already established, I think.
So it's building on that.
Yes. Yeah.
Any of my colleagues have any further questions? Well, Mr. Ephgrave, thank you very much for taking the time to give evidence to us today.
Thank you very much for listening.
And been very helpful to us. If there's any additional material that you want to provide us with, anything that sort of dawns upon you after you've left, do by all means just write to us and send that in. And can we wish you the very best and never success in your tenure of office. And even if we may not see you again in the current makeup of the committee, I'm sure our successors will look forward to that. We look forward to working with you whilst we're still here, because you may be here longer than some of us are.
Thank you very much, everyone. It's been a pleasure being here. Thank you.
Thank you very much. Meeting's concluded. Order.
The proceeding has ended. 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 The proceeding has ended.